Hello, everyone. Welcome to another Agenda IDS. I am Patricia Porto, the Academic Coordinator of Dannemann Siemsen Institute. Agenda IDS is an online event in which we address important topics regarding intellectual property, law, and technology. I always invite experts on the subject to share the experience with us. And those who miss the live event will be able to access the record content available later on Dannemann Siemsen Institute website. And today, we will discuss aspects related to proving trademark use in order to maintain the trademark registrations. This is a very relevant topic in trademark that will be discussed by three experts on the subject from the perspective of China, European Union, and Brazil's regulations. And now, please, let me introduce our guests. To talk about the issue under China regulation, we invite Ms. Lena Shen. Welcome, Lena. Lena is a lawyer. Welcome. Lena is a lawyer and a trademark attorney specialized in trademark prosecution and IP enforcement in China. She's a senior partner of Dakun IP Law Firm in China and a bureau member of AIPPI. And to discuss the matter as regulated in European Union, we invited Klaudia Błach-Morysińska. Welcome, Klaudia.
Good morning.
Klaudia is a lawyer, a patent attorney, and a European trademark design attorney, specialized in intellectual and industrial property law, copyright, and regulations dealing with unfair competition practice. She's a partner at Dannemann Law Office in Poland and board member of IPPI. And to moderate the event and talking about the subject from the Brazilian perspective, we invited Rafael Atab. Welcome, Rafael.
Thank you, Patricia. Good morning.
Morning. Rafael is a lawyer and a trademark attorney. He's a partner at Dannemann Siemsen, member of the Dannemann Siemsen Institute Advisory Board, and IPPI board member. His practice focuses on strategic management of intellectual property rights portfolio, with a particular dedication to complex matter in trademark fields. I would like to thank very much our guests for being here with us today. And now I will give the floor to Rafael. Thank you very much. Rafael, the floor is yours.
Thank you, Patricia. Thank you so much for organizing this event. And a special thank you to Lena and Klaudia to joining us today to discuss about this very interesting topic. And I say it's very interesting, very current for two main reasons. Because first, it was the subject of a resolution from AIPPI just last year, proving trademark use. And I guess most people know about AIPPI. AIPPI is one of the most traditional IP associations in the world, with almost 9,000 members from all over the globe. And we discuss a lot on subject matters regarding IP. And every year, the members propose 4 topics to be discussed and potentially to become a resolution. And trademark use last year was one of them. And by coincidence, last year, the Brazilian Patent and Trademark Office also implemented a new regulation on non-use cancellation actions and actually changed some quite long-standing approaches and standards when it came to proving trademark use. And I would cite right now 2 of these aspects, and during the entire webinar, we'll also learn a little bit about other ones. But the first one was that, and as you might know, Brazil has a 5-year grace period for the start of using. After 5-year registrations, any third party may initiate non-use cancellation actions. So one of the big changes was treating these initial 5 years as a really grace period where use cannot just need to be started and not proven all the way long. And another aspect was, for the first time, the BP2 addressed online evidence of use. So these are some of the issues that are going to be discussed today. And I'm very grateful that I see right now a very international audience, not only our traditional Brazilian audience in these IDS events, but also people from other countries as well, probably interested about China, Europe, and Brazilian experiences. And so, as I'm also very keen on understanding a little bit more what happens in China and in Europe, I think we can start listening a little bit about it from our guests today. And I would start by asking, and let's start with you, Lena. How is it that China regulates, from a broader perspective, non-use cancellation actions? Is there a grace period? How does it work in China? How many years for you to need to start using the mark? And how does it work in practice? And we are here talking about practice when it comes to someone challenging another person's registration based on non-use. Thank you, Lena.
Yeah, sure, Rafael. Glad to make some introduction of the overview picture of the use requirements in China. Well, only when I prepared for this webinar, I realized that our 3-year grace period is different from the grace period in Europe or in Brazil, probably. In the Chinese law, it said that any trademark may be cancelled if it stopped using for continuously 3 years from registration. It means that for the first 3 years, you also need to use. Actually, if you stop using even in the first 3 years continuously, you will have the risk of being cancelled. I mean, the trademark. Basically, China is the first to file country, so the use requirement is not as like in the US. So we do not require the use before filing an application or before being registered. Not even intention to use. So in this respect, it's close to the European practice, but according to the current Chinese trademark law, in principle, the trademark application should be filed for the purpose of use. And after 2019 amendment of the trademark law, Article 4 of the law says that application for the trademark registration that is malicious and not filed for the purpose of use should be refused. That means the examiner can challenge it, actually. If they are suspicious you are filing the trademark not for actual use, for instance, they probably suspect you filed the application to register trademark for sale of the trademark per se, then they may have the right to invite you to provide use evidence or evidence or to prove the intention of use during the examination. It happens already a lot, especially in the recent years, especially when the applicant file a big amount of applications in short period of time. It happens to many big internet companies because they often file like hundreds of trademarks one time or in a short period of time. So one really a top internet company in China received many, and they complained a lot of this practice, but they need to reply by submitting evidence. If they cannot prove the actual use or intention of use, then the trademark will be refused. By saying that, basically, you will receive the registration certificate without proving any use. It's only when a third party starts a non-use cancellation application, you will need to prove your trademark use. It is 3-year period, different from the 5-year period like in Brazil and in Europe. So we always advise the clients to start using the trademark within the first 3 years after registration. Otherwise, it will be a risk to lose it if somebody starts the cancellation proceeding. So that's the basic and overall picture of the non-use cancellation or the use requirement in China.
Well, thank you, Lena. I think that's very interesting because when you file in China, even though it's a first to file country, you also need to be attentive of acting in good faith and avoiding anything that might indicate that you're not actually going to use the mark, but actually just filing it for protective or defensive methods or something like that. But Klaudia, what happens in Europe? How do you also have a grace period similar to Brazil, or is it different, more similar to China? And particularly, one question that I have is, do you need to initiate a separate non-use cancellation action, or can it just be argued in another procedure?
Okay, thank you, Rafael. Thank you for having me here, for inviting me. And referring to Lena's, in spite of this 3 years term is in line with TRIPS, I think that our clients more would like to have these 5 years that we have in Europe, you know, because it's always 2 years plus to start business, to start the preparation to using a trademark. So in Europe, if within a period of 5 years following the registration, the trademark holder is not using the trademark in European Europe in connection with goods and services for which it was registered, or such use has been suspended for an uninterrupted period of 5 years, such trademark will be subject to the sanction provided by the trademark regulation, unless there are proper reasons for non-use. And what are these sanctions? One of the sanctions is the cancellation due to non-use, as you mentioned, but other sanction is that such trademark cannot be effectively used in a pending proceedings, because the other party may ask for the proof of use, and if such proof of use is not provided, then the cancellation or opposition will be simply rejected. You asked if the cancellation proceeding may be started just before the office or in the other proceedings. So you can start the cancellation proceeding in administrative proceeding before the office, and then you are obliged to file a separate cancellation motion. We call it revocation motion. And then you have to just put the statement that the trademark is not used within the uninterrupted period of 5 years, and that's all. And the other party, the trademark owner, have to prove that the trademark is used. You know, so the trademark owner is the one who has the burden of proof that the trademark is used, and the other party doesn't have to do nothing. When you're filing the cancellation motion, you don't have to make any research or justification. It is enough just to file such motion. And the second possibility to file the cancellation motion due to non-use is the court proceeding. For example, if you've got the claims referring to trademark infringement, and the claims are based on a trademark, which can be cancelled, then it is enough to file a counterclaim, including such cancellation request. So there are two ways when you can file this cancellation motion, and additionally, in opposition proceeding or in cancellation proceeding, as I said before, you can ask for the proof of use. This is not a typical cancellation request, because after examining this proof of use, and if the use is not proven, the trademark will not be cancelled. It will be treated as existing in this very proceeding, so you cannot base your claims on used trademarks. So it is useless for fighting for your rights. So there are two cancellation proceedings: before the office in administrative proceeding and before the court in pending civil proceeding. Plus, you can use this proof of use procedure.
Oh, that's very interesting and very complicated as well. So if you're in Europe, you have different avenues to try to enforce the use of the trademark against someone trying to challenge your application. So and it's probably very useful to applicants as well. And perhaps it matches the very purpose of a trademark, is that it's being in the market, identifying goods and services, and actually helping consumers to choose their goods and services and avoiding confusion. So if it's not doing that, what's the purpose of it even existing? And avoiding third parties from actually trying to use something that it might be similar. So, but another issue that comes up when we talk about use and particularly proof of use is the amount of these of the pieces of evidence that need to be submitted. And this was a quite big change here in Brazil with the regulation that was implemented last year, because we changed from a very lenient approach. The BPTO would often accept any little amount that would evidence that, well, the registrant used the mark at some point and some of the goods were sold, and that's fine. I don't want to look at it very deeply. But right now, when the office starts to actually requiring effective use throughout the 5-year period, they start looking deeper into the evidence that is being submitted, and the amount of it sometimes is a very important aspect. According to current regulation, there's no fixed amount. It will depend on the field of business and other circumstances. These circumstances are not very clear in the regulation, but I would guess that they would also depend, of course, on the size of the company. And we do have a precedent on that from our Superior Court of Justice, saying, and the case was relating to cigarettes, and the registrant that was having their trademark canceled was a very, very large multinational company, which was only able to submit a few hundred packs of cigarettes being sold in the entire 5-year period. And the court say, okay, you're very large. It makes no commercial sense to sell only 100 or a couple of hundred cigarette packs. So it's not sufficient evidence of proof of use. But then what happens in Europe, Klaudia, when it comes to the minimum amount? How is it reviewed by your local authorities?
There is no one-size-fits-all rule regarding the standard amount and amount of evidence, that you should submit to prove the genuine use. First of all, you have to prove that your use is not token, so that your aim is to enter the market or to keep the market. This is very important, and the evidence should relate to the trademark and to the goods and services covered with trademark. This is a crucial thing. And they should, of course, refer to the period we are arguing about, and it should refer to the relevant territory. And this territory, as you know, the European Union, it's not one country. There are several countries. So there is always a question, is it enough to use in one country? For example, just in Poland, or maybe you should use in number of countries. So this is always an issue. So there is a very well-known O'Neill case where the court said that the European Union is one market, so we cannot refer to the countries. But in practice, you should prove that the market that you are using this trademark, even if it's a small market, is very important for you. For example, in one of the cases, it was enough to prove the use of some IT services in the area of Thames River next to London. Just such a small area was enough to prove. So this territory is quite relevant. And about the numbers, it depends on the market we are referring to. Sometimes you said about this tobacco producer. If it's a big tobacco producer, and cigarettes are quite commonly used, so probably we would require bigger amounts, or bigger invoices to be introduced to the market. Or maybe some kind of marketing as well. But when we refer to the small companies that, for example, are producing just very specific goods, like, for example, some veterinary stuff or some special nutrition for soil. There were some cases like this. It was enough that the small amounts were introduced to the markets. So it really depends. But the very important thing is that the evidence you present must, as I said before, must show that the use is not just for keeping the trademark alive and not really using trademark on the market. So I think that this is why one of the most important thing to prove, but there is no one rule how to prove it and which amount are required.
Thank you, Klaudia. This is very interesting. I think when it comes to our three jurisdictions, we have a large territory for all of us. So it's Europe, Brazil, and China. And at least here in Brazil, it doesn't matter if you're a small bakery or if you are a large producer of beer distributed worldwide, you can have a trademark registration. And of course, the amount of use will be different from the requirements from each of these companies. So I'm very interested to learn what happens in China as well. But just before I pass the word to you, Lena, I just want to let the audience know that this is a round table. So if you want to make any questions, please, you're free to do that. And we'll be more than happy to answer and read your comments as well. And once again, thank you so much for joining us here today. But Lena, what happens in China when it comes to amount, when it comes to use throughout the territory, either if you're a small bakery or if you produce all the bread in China?
Right. Well, China is one country, not like European Union has 20 plus countries, but we do have like 31 provinces in China mainland. So the situation probably similar to multiple nation body territories. But I think the rules in this regards relating to this question are more or less the same, or or maybe similar, if I put this way. So in China, also there is no explicit provisions on the amount of evidence required or the minimum amount of evidence in proving a trademark use. It is really a case-by-case judgment, and industry from industry and company from company. So really very case-by-case issue. But the basic rule is that you need to be really genuine use. Your use is really to make a commercial use. It's not a token use. I think the examiners and judges are very smart in this regard to tell in most of the cases, so they can tell which ones are like created token use just enough to maintain the trademark. Some probably, although in very little amount of evidence or sales, still can maintain the trademark registration. So the examiner will and judge will make assessment in consideration of the different factors, including like which industry it is, what kind of business models in this industry running, and also the marketing or the business customs, etc. So with all the consideration of all these factors, the conclusion will be made after the overall assessment. Similar to Klaudia's case, if you are with too little evidence, it is likely to be decided as a token use or symbolic use, which will not be sufficient to maintain the registration. In one case, the concerned trademark was registered in class 25 on the clothing products, and the registrant submitted a perfect evidence train, including the contract, the invoices, the picture of the products, etc. So with this evidence train, it's complete to prove time, all the elements they need to prove. But eventually the examiner decided that it is too little. And in the clothing industry, within several years, you only have one sale. It's really abnormal for such an industry, and it's not make a successful or even not a normal business. In such a case, such a use was determined as a token or symbolic use, so the trademark was cancelled. But if in another situation, for instance, the product is very high value or very precious, and the business or the consumer's needs is not high at all. So to sell like one time a year probably can feed the trademark owner the whole year. In such a case, it will be sufficient if it's only one sale. So it really depends on the industry. And then regarding the evidence chain, I mean, it's not. We need to prove several facts to in with the evidence. Generally speaking, it is to prove who, when, and where used which trademark on what goods or services. Only to prove all these information, these facts, the evidence can be accepted as valid or as sufficient. But it's not necessary to include all the information in one single evidence. So as long as the evidence train as a whole can prove the use period, which mark, who are using, and on what goods, then it could be taken as valid and sufficient trademark. When regarding back to the amount of evidence, I should point out that some of the use are definitely not enough. first just to publish the trademark information or the registration or ownership of the trademark. It's not enough. The second situation is to use the mark in a non-public domain is not sufficient. It won't be regarded as commercial use, such as to use internally in the office, but not to sell to the consumers. Or you produce it, but did not put the products into the market. Such use are all taken as internal use, so it won't be sufficient. And the third, just to provide a trademark license agreement, but without any actual use evidence, it won't be sufficient. So these are also not sufficient use case. Regarding who can use, I think according to the submission by different national groups when answering the study questions, it turns out that in most jurisdictions, the user can be the registrants, can be the licensee, can also be other authorized parties. In China, the same. So here, think regarding the person, it's not strict. So even the unauthorized party who used the trademark, but afterwards was approved or agreed by the trademark owner, it will be fine.
May I use something here?
Yes.
Yeah, may I add something here? This is very interesting. The last issue you said that unauthorized use shall be also treated as genuine use. So this is different in Europe, you know? If this is unauthorized use, it will not be used as the genuine use because it was not the intention of the trademark owner that this trademark is used on the market or on this relevant territory. So this is really interesting, and this is important difference, I think, to remember to all of us who want to prove the genuine use in China. Because in my mind, it will be impossible, you know, I would never thought about sending you this kind of evidence. So it's very interesting thing. Thank you.
Yeah, in some cases, we could not find the direct use evidence by the owner or by the licensed party, but third party may do that without awareness of the trademark registrant. For instance, some media, some influential, the what's the word for that? Those celebrities or on the internet who sell the product without. Yeah, influencers. They introduced the product into China, and then we took these evidence as submitted with the office, and they were accepted in some cases. Of course, it's case by case, but it's very likely to be accepted.
I think this is very interesting, and I think it addresses Suzanne Finkelberg's question when it comes what type of evidence. And regarding this authorization or lack of authorization, it's also a little bit different in Brazil, because here the PPTO sometimes even requires some sort of written authorization if the evidence of use refers to a third-party use. But then, and as you were talking, I was starting to think about those sort of uses that the owner of a trademark cannot forbid. For instance, the referential use of a trademark or using relating to spare parts. And if they are obliged to and required to accept such use, why can't they use it on their own behalf? So that's something that we could think about. And particularly when it comes to the aspect that one of the targets of trademark protection is also protecting consumers. So if the trademark is being used in the marketplace and the consumer is being able to actually understand that this is a trademark originating from some sort of source, if a third party will be able to get a registration just because the owner was not able to clearly evidence use, even though the mark was being used effectively in the marketplace, that could hurt the consumers in some way. So that's, I'll have to think about it a little bit better, but it's kind of interesting, and I don't think this was addressed by the resolution of AIPPI, so perhaps you're gonna need a new resolution on this one. But one quick question still on Suzanne's question. What about publicity material? Is it considered sufficient, or does it need to come with effective sales or effective agreements? How does it work in Europe and China? Maybe you can start with Europe. Publicity material and advertisement, is it enough?
Yeah, just advertisement and just marketing materials. You are asking always not obvious questions, you know, because this is always disputable issue. In general, in European Union, the advertisement and marketing may be treated as a genuine use evidence, but in most cases it will be just supportive evidence. You know, there is a big discussion in doctrine if it's possible, because when you use the trademark, you have to use it in its primary function, which is the origin, you know, showing the origin and giving the consumer the origin of the goods. And marketing function is something else. So there's a big discussion if this marketing, without entering the goods to the market or services to the market, if it's enough. And you can find verdicts and decisions that the courts will say, yes, it's enough. But for example, in Poland, you can find mostly the decision that it's not enough to provide just the marketing materials. As a general rule, the means of evidence, you can present everything. Yes, of course, the most valuable one are invoices, because it's always the strongest evidence. Invoices, offers, packagings, labels, price lists, catalogs, photograph, press advertisements. You can file affidavits. And even you can have witnesses, you know, as an evidence, but it is not very popular before European bodies to listen the witness. So if you file the marketing materials plus all the other evidence or supported by some invoices, it might be enough. But if it's just marketing materials and there is no proof that the goods are or services are on the market, I think it might not be enough.
Thanks. And what about China, Lena?
Well, in China, advertisement is a way of using the trademark. In most cases, if you advertise it, for instance, in TV show, in an exhibition, or on the internet, in many cases, it can be accepted as valid use, unless it's really too symbolic. Just once a year, probably just enough to maintain, then which will be taken as token use. Other than that, generally speaking, it can be sufficient to maintain the trademark. I think the rationale behind it is you don't need to be successful in business. You advertise it, you try hard to sell, but at the end, you do not make it. It's still allowed. So if you can provide those marketing materials, and also to prove that such materials are actually be sent to, or they reached the consumers or potential consumers, it is likely or very likely to be accepted in such a case. So marketing materials, advertisement materials are valid. One of the valid, evidence in China acceptable. Of course, there are exceptions, but generally speaking, yes.
Great. And there's another very good question here from Anna Hackers about what happens when the good is given out for free. And we did have a case here in Brazil a few years ago. It's the manufacturer of computers and software, and they actually changed the market a couple of decades ago when they decided to offer their operational systems for free. So you could just keep downloading the new versions, and each new version would have a new name and then a new trademark. But at some point, we had to evidence use of it. And the Brazilian Trademark Office actually accepted the download links and evidence that that the software was embedded in some of the products, and that happens when the device already has some of these softwares, and the links for downloading and updating the operational system. And I don't know any case of it, but perhaps with free applications for cell phones, for instance, it might be the same. I don't know what happens right now, what's going to happen with the current regulation on the DPTO, because now they adopt a more stringent standard. But if it's there, it's in the marketplace, a consumer can have access to it, why not? I don't know if you have any case law on that, Lena or Klaudia, that you wanted to share, but I think it's, as Lena said, it all comes down to the rationale behind it.
Right. Well, in China, to have a giveaway of free products to be given to the consumers together with the other services or other goods can be a way of use in many cases. There are different conclusions in different cases, but we saw in some cases, at least, the judges and the examiners do accept that. I think it is reasonable to accept such a way of use, because although it's free, it looks like free, but it's not really free. It either go with the other sell the products or other sell the services or serve the overall business advertisement of the registrants. So I don't think it's really free. Even it is free, it's still a use. It does not say that you have to exchange it with the money or with a price. So I do believe the giveaway products or giveaway services can be a use to maintain a trademark registration as well.
Yes, so the same is in Europe. You know, in 2008, we had the very famous Radetzky case, and it referred to the charity organization, and they registered a trademark and were using this trademark, but just on the festins, just to market their promotional materials, just as an emblemate. And there was a question, is it the genuine use of the trademark, you know? And the General Court said that these non-profit organizations, they can register a trademark, of course, and it is obvious that they are not doing it for money. So they will not sell anything. They will not earn money on using these trademarks. And the genuine use of the trademarks doesn't have to be connected with earning money. You know, they can be competitor on the market, and they may fight, for example, for the members. They may have another profits from using these trademarks. And that's why even if you use the trademark for the free products, it doesn't mean that it cannot be genuine use.
Thank you, Lena, Klaudia, about this one. I agree completely and think that would also apply to Brazil. But there's another very sensitive aspect that has changed here in Brazilian law, which refers to a change in the trademark itself from the mark that is being featured in the certificate of registration. And when you try to evidence use of that mark, you only have some sort of newly designed mark, a mark that has been used with some small changes, sometimes big changes, a different color, a different letter font. In the past, Brazilian office was very, very strict about it. If the mark being in use did not match exactly the mark showing in the certificate of registration, the mark would get canceled. But in this latest regulation, they changed it a little bit, saying if the changes do not affect the overall appearance of the mark, the distinctive nature of the mark, then it's going to be accepted. Here in Brazil, you cannot amend the registration. It's going to still be the same way that it was applied for, but the changed use will be accepted as evidence of use of the mark as registered. So, Lena, how does it happen in China?
Well, in China also, once the trademark is filed, you can't change it at all unless requested by the examiner. For instance, you put an R there, which should not be part of the trademark. Then the examiner probably will ask you to remove it. If not requested by the examiner, you are not allowed to change anything after filing. So it happens often. The actual user trademark is different from the registered trademark. Just as the resolution of the AIPPI concluded that as long as the distinctive character of the trademark not altered, then it should be taken as valid use. It shall be tolerated. In China, we follow this rule. But the question is, how different is different? So this is a difficult judgment, and also it's a very case-by-case judgment. We may, I want to show you some examples so that you will have a more direct idea how in China we assess what is unaltered trademark. So let me try to share. Oh, not this one, different one. All right. Can you see now?
Yes, perfectly.
Yes.
Great. So let's see. Well, here I make some summary of the general rules on whether a distinctive a character of mark is altered or not. So in general scenarios, well, there are some common scenarios where the examiner or the court will think there is no substantive change, or the distinctive character of the mark is not altered. So the first one is to change the positions of the compensate element. For instance, to change the up-down arrangement to left-right arrangement. You will see some case later. And the second is to use one distinctive part of a combined mark. For this one, there is a bit of debate. But in some cases, we do see that the trademark office maintain the registration in such a case. And the third one is to use color for the black and white mark. And the fourth one is to use the mark together with other marks. That means on the same product, you will see multiple marks. It's also allowed. And the next one is to omit or add the non-distinctive elements. In this case, in almost all the situations, such a change is accepted. And the next one is to change the font or the size of the letters or the characters in the trademark. And in some other situations, the judge or the examiner will consider the business customs to decide, although there is some change in actual use, but such a change is very commonly seen in the business, in the industry. So they are accepted. For instance, for the service marks, if the trademark owner use on the side sign born or on the gate, on the door of the shop, they will make some change to their trademarks due to the condition. Such a change normally acceptable. And in some other situations, like the marks with devices, then when the parties mention the trademark in the contract, in the invoices, it's very often that they will omit the device part or use some words to describe the device part. Then it is also allowed. But in China, there is one special exception for this rule, which is probably different from Europe and maybe Brazilian as well, which need to be confirmed by Rafael. That is, if the used trademark itself is a registered trademark, then the trademark office will cancel the contested trademark. They think it's not necessary to maintain both. Since you only use one of them, why we should maintain, keep both the trademarks for you? So in such a case, probably to register more trademarks is not always a benefit to the registrants. Now let's look at some examples. The first group is to use the Chinese characters part only for a combined mark. You see the two register marks are both combined marks with the Chinese characters and English words or Latin letters, and the other even with the logo, but the actual used one is only the Chinese characters. They were accepted in the final decision, although you see before the trademark office in the cancellation review case, they thought it's not sufficient. It altered the distinctive character, but finally the court decided that it does not change the distinctive part, so they maintained the registration. These are the one group of the cases. The second group is to combine with another trademark. I think this is easy to understand and also more reasonable to maintain, since the register mark still can be separated or easily seen in the actual used mark, like WSB is still there as WSB, although there are some other parts in the front, and the logo plus the boy word, but the logo can still be seen and distinguished. So in these cases, they are also maintained and accepted as valid use of the registered trademark. The second one, the third group is to add non-distinctive elements. But here, they use the trademark or Chinese character trademark, but let me make some Chinese lesson here. The last character for the first trademark is Wang, which means network or internet, or just net. This trademark is registered in class 42. This character is deemed as non-distinctive. So to add this character, the judge thought does not change the distinctive part of the trademark, although the trademark is a combined Chinese character and the Latin letter trademark. So eventually it is maintained, the registered trademark. But the second case has a different or the opposite fight, because in the second case, the trademark office thought it's valid use. It should be sufficient to maintain the registration, but the court ruled that it's not. The reasoning of the court is that the registered trademark there are two characters, although with design, the two characters means nature. But with the designs, nature, the word is not very distinctive in class 5, but it is registered because it has very special designs. And then the actual use trademark is 自然饮, which means natural drink. So there is one character more than the word of the registered trademark. The court explained that, first of all, the design is totally different because the actual use one is just the pure normal character, but the registered one with special design. And second, natural drinks and the nature, the meaning are different. So the court did not accept the altered use as sufficient or valid use of the registered trademark. So these are different conclusions with a similar use. And the fourth one, I think, without challenge, first to change the position of the composite trademarks, all the tribunals agree that it's valid use. They only change the up low arrangement into left and right. And the last one is exactly the one I mentioned, especially that if the use trademark itself is a registered trademark, then the challenge trademark will be cancelled. Like in this case, the actual use trademark is another registered trademark by the same registrant, and then the first one, the challenge one was eventually be cancelled. So with all these rules, I will just want to give you a very quick overview of different situations where the trademarks can be, whether they are substantially different from the register or not.
Thank you, Lena. This is very interesting and very difficult as well. So if I'm having an issue in China, I really need a Chinese attorney to tell the difference between what's valid and what's not, particularly with the Chinese characters. And Claudia, what about Europe? How does it work there?
Yes, you know, in Europe, we have special regulation that says that use of a trademark in a form differing in elements which don't alter the distinctive character of the trademark, it is still the use of the trademark. And it is put in the regulation and it is quite clear. And I think it's good regulation because law must go in line with your business. And when we see now everything is going to be simplified, you know, all this complicated logo now, they are going to be simple because people are using them on small iPhones, or they are looking then on small surfaces. So everything must be easier and smaller. And that's why I think it's good to have such a regulation. This issue was a big issue in Europe in 2015. The European Union is such an institution that we are trying to work on common practice. And EUIPO is organizing such working groups, and there are different topics connected with trademarks and issues from the regulations. And one of these topics were how different is different. Yes, so what kind of alteration of the trademark may keep the trademark still alive. And I will share with you some. I don't know if you can see the document with fishes. Yes. So
Yes.
these are the principles of this common practice. And the first thing is that, first of all, you have to assess the trademark as it is registered, and you should take into account its distinctive and visual dominant elements. And the next step is that you should assess whether those elements which are distinctive on the registered trademarks are present or modified in the trademark as used. And you should do it side by side. You should look at these two signs and decide. So I will go quickly now through the examples that are in this common practice, because I think it's nice illustration for the topic we are discussing. So first of all, when you look on these first fishes, on the left, you've got the trademark as it was registered. On the right, you have trademark as it was used. So when you add this blue fish, which is dominant to the red fish, and you can barely see this red fish, so this will be the alternation. And this alternation cannot be accepted. But if you have a distinctive word element and you add the also distinctive fish, but they are still in the same position in the trademark, they have the same dominant position, so this might be accepted. And next we will go to the addition of non-distinctive elements or elements of low distinctive character. So here we have the trademark Garivan. If you add non-distinctive oval element or non-distinctive word element as bio, this still be the use of the trademark. But if you have a trademark flavor and aroma for class 31, which is weak, and when you add banana to this trademark, and when you see that you cannot find this floor and aroma, so probably it will be judged that this kind of addition, it's an alternation of distinctive character of the trademark as registered. So probably it will not be accepted. And considering the omissions, if you delete the descriptive element bio, as in this down example here, it still be good example to say that there is no alternation of distinctive character. But if in this example you have two distinctive words, Garivan and Bubblecat, and you get rid of one of them, probably it will alternate the distinctive character of this trademark. But if this Bubblecat is written in a very illegible way and you get rid of this, probably that it will have no impact on the trademark as it was registered. So probably it will be accepted. And the same with this Garivan and with this non-distinctive element. When we go to the word trademarks, when you've got the word trademark, it doesn't matter about what font, what color, size, and position you will put it. It is always will keep its distinctive character, and it will have no impact on the distinctive character. There is one example that can be shown as alternation of this, when you cannot read the word because it is written in such a font that you cannot identify this word. So this will be the alertation of the distinctive character. With the purely figurative trademarks, I think that this banana is a very good example for this case. If you have a trademark in a very simple shape of banana for goods in class 31, if it's registered in purple, I think that this purple color is something which is distinctive, because banana for fruits is not distinctive at all. So this kind of color is something dominant and distinctive. If you are using just yellow banana, you are not using this dominant element of the trademark, which is this color. So as a matter of that, it will be the alternation of the distinctive character of this trademark as registered. And with these composite trademarks, we have already discussed it, that when it refers to the verbal elements, use of those elements in different color, in different font, size, will not normally alert the distinctive character unless you have this illegible word that you don't know what is the word, if it's the same word as a trademark. And with the composite trademarks with figurative elements, the modification of these elements when we have these two mountains and we just switch left to right, right to left, there will be no difference, between these trademarks. But when we change the shape of the amount, as it's in the bottom example, and we leave just this descriptive element, best quality, there will be a big difference, and it will alert the distinctive character of the trademark. And it's very a nice case here with this bubble catch. In this trademark, when you can see here, the very distinctive and dominant is the font and the shape of this word. So if you have such fantasy logo and you are just using the normal font, the very regular font, the dominant element, which is this graphic presentation, is missing, so you cannot read this trademark. So it will be alertation of the distinctive character. And very one important comment which should be done at the beginning, that the trademarks, the two registered trademarks that are used together, we never consider it as using the trademarks in a form different than registered. It is always the use of two separate trademarks. So we don't use this kind of examination for two trademarks which are registered separately. So I think it's quite different that it is in China. And so it was very quick review, but I know that we are short with time, so I stopped sharing it. But as I said, this is very good. This is very good regulation. If you are interested, you should review this CP8 common practice, and there is plenty of trademarks to read and examined. Thank you.
Thank you, Klaudia. I think and reviewing and watching your presentation, I think Brazilian practice is becoming quite similar to the European one. We also have some examples, much less examples, but still some examples are very similar to those used in Europe here by the new regulation. And Lena, the point that you raised on, well, if you already have a registration for that one, it won't be sufficient to show use with a different trademark registration. We still didn't get to that particular place in Brazil. I think that question was never raised. I don't know what the answer would be here, but it makes some sense. If you already have the registration for that type of use, why do you need another one, another registration to be maintained? But at the end of the day, I think in all our jurisdictions, one thing that one aspect behind of it is how the consumer sees it, and is it sufficient for the consumer to understand this is the same trademark and this is the same source, this is the same origin, and does it work as a trademark to protect the producer, but also to protect the consumer? I think these aspects are always questions to be asked. And well, we are indeed almost out of time, so perhaps just one final quick question is, when it comes to online use, what we do there? How to evidence use when the use is online? Because sometimes it's difficult to get dates. It's difficult to see that there has not been any changes since the publication. Here in Brazil, it was the first time that online use was discussed when the BPTO implemented that one, but it has not been fully tested by our courts. So I don't know, Klaudia, if you have any comments when it comes to Europe, that would be great to be shared with particularly with the Brazilian audience here today.
Yes, of course. The use of a trademark on the internet or on the website could constitute a genuine use. There are no special regulation on that. The same principles apply to internet use as to the offline use. And what is very important, that the use should be targeted to the recipients within the relevant territory. So the use should be addressed to the recipients in Europe. So what we should prove? We should prove that there is a sale of goods or the provision of services made to the EU consumer. We should prove that this website is in one of the EU languages, that the goods are offered and sold in EU currencies, that there is, for example, a head office of the trademark owner somewhere in Europe. Maybe they have some kind of service center in Europe that European consumers can contact them. What else? Maybe there is some local telephone number, maybe some local address provided on this website. I think that very important thing would be that the trademark owner runs a business in Europe, so in one of the European countries. So I think that it would be very important. And very important thing is that the use of the trademarks needs to be related to the goods already marketed or just about to be marketed, because it means that these goods are present and the EU consumer is familiar with them. The internet materials and sources could be accepted as evidence of use of the trademark. The catalog of this evidence, as I said, is open, so you can present also the materials from internet. We have another common practice. As I said, we Europeans are good in common practices. This one is CP12, and this is the common practice on evidence in trademark appeal proceedings, but it is commonly used by EU IPO and EU member states offices as well. And this document specifies the practice, especially in regarding to filing the evidence. So I think it's good. If you need some advice, you can look to this practice. And one more very interesting case, for me it was really interesting, and I think that for my European colleagues as well. It's the standard international management case. It was issued, I think, last year, and the case referred to the hotel services, and the hotel services were offered in US, so outside Europe, but it was advertised in Europe, and the advertisement was directed to the European consumer. And the court said that in some specific circumstances, use of the trademark can be considered as a genuine use when it relates to advertised services, where advertisement and offers are aimed to the consumer in Europe, but the service as such are only available abroad. So it was very interesting case with very interesting verdict, very non-common, you know, and it refers both to the offering services online and to the advertisement, as we said before, you know. So as I said, that these goods should be on the market, but it should in general be an EU market. But with this judgment, you can say it's enough to advertise, online advertise, and use the trademark for the services outside EU. So I think it's quite interesting. And due to the time, I will put full stop here.
Thank you, Klaudia. And this is really, really an interesting case. And Lena, you mentioned influencers and social media. So how does it work in China?
Right. Well, the online use can be accepted as valid use for sure, but it needs to meet certain criteria. The criteria actually, generally speaking, the same as the assessment of offline use, and it's also a case by case assessment. Similarly, as the offline use proving, the registrant should prove when and where, who used the trademark on what goods and services. So I think for the online use, the territory, I mean, the use territory assessment is probably the most challenging one, since there is no physical boundary for the internet, for the virtual world especially, and the different factors should be considered. Normally, what will be considered include like the accessibility of the internet, or of the web page, or of the app by the consumers in China, whether the actual shipment of goods happened, I mean, into China happened, and like the currencies or languages adopted on the website, or on the virtual apps. So the assessment will be made after considering all the different factors in this regard. But for the evidence, if you download a web page, then the difficult part is the time proving when such a for instance, offer for sale happened. You need to prove. This is also difficult. So nowadays, some of our clients, that what they do is to do the evidence preservation from time to time and keep them in the dossier, so that when they need it, they can use it. And nowadays, with like blockchain or other tools, such evidence preservation become very cheap and reasonably affordable for most of the trademark owners, and also simple and easy. So it's advisable to keep collect evidence and keep evidence from time to time, just in case you need them one day to prove the actual use.
Thank you, Lena. Just in case is always what lawyers say. So this is very good advice. And well, I think we're out of time, right, Patricia? Thank you so much. Before I give the floor to you, Patricia, I would like to really thank Lena and Klaudia for joining us today here. It was amazing. Yeah, and that's why I always say you are IP stars. We can ask any questions and you know it. So thank you so much. And a last announcement for any AIPPI member here. I just heard that the questions for 2025, the Japan Congress will be released today, so you can all the delegates can vote on what the questions will be discussed. And before that, I hope that any AIPPI member here will join us in Hangzhou, right, Lena?
Yes.
So that we can.
Tom, please come.
So we'll see you in Hangzhou and discuss a little bit further. Thank you, Patricia. It's yours now.
Thank you, Rafael. I would like to thank you, Lena and Claudia, for all the knowledge you share with us today. And thank you, the audience, for the participation. And I would also like to invite the audience and you, Lena, Claudia, Rafael, to follow the Dannemann Siemsen Institute on our social media and website to follow the news. For example, in June, we will have another Agenda IDS, this time on strategic litigation management. So stay tuned to all the new projects we are preparing for you. And it's all. Thank you and see you soon.